In view of the legal principles laid down by this court in the above judgment, the reference of the industrial dispute made in the case on hand by the state government to the labor court to adjudicate the existing industrial dispute between the parties was made within a reasonable time, considering the circumstances in which the workman was placed. Firstly, as there was a criminal case pending against him, and secondly, the respondent had accused the workman that he would reinstated after his acquittal from the criminal case. Moreover, it is reasonable to adjudicate the industrial dispute in spite of the delay in raising and referring the matter, since there is no mention of any loss or unavailability of material evidence due to the delay. Thus, we do not consider the delay in raising the industrial dispute and referring the same to the labor court for adjudication as gravely erroneous, and it does not debar the workman from claiming rightful relief from his employer. Para. Hence, we are of the opinion, having regard to the fact and circumstances of the case, that there is no delay or laches on the part of the workman from the date of his acquittal in the criminal case. Thereafter, upon failure of the respondent in adhering to the assurance given to the workman that he would be reinstated after his acquittal from the criminal case, the workman approached the conciliation officer and the state government to make a reference to the labor court for adjudication of the dispute with regard to the order of dismissal passed by the respondent, keeping in mind the date of acquittal of the appellant and the date of which he approached the conciliation officer by raising the dispute. Since the respondent had not adhered to its assurance, the state government had rightly referred the dispute for its adjudication. Therefore, it cannot be said that there was a delay on the part of the appellant in raising the dispute and getting it referred to the labor court by the state government. Para. Further, the labor court, on an erroneous assumption of law, framed the additional issue regarding the limitation in raising the dispute and its reference by the state government to the labor court. Thus, the labor court has ignored the legal principles laid down by this court in the cases referred to supra. The award passed by the labor court was accepted erroneously by both the learned single judge and the division bench of the High Court by dismissing the civil writ petition and the latter's patent appeal without examining the case in its proper perspective, keeping in view the power of the state government under section 10 and the object and intendment of the act, not adjudicating the existing industrial dispute on merits between the parties referred to it, may lead to disruption of industrial peace and harmony, which is the foremost important aspect in industrial jurisprudence, as the same would affect the public interest at large. Over.